Mr. John Aikpokpo Martins, who is the first vice president of the NBA. Good morning, and thank you for joining us on the program today. Yes, NBA did speak up about this matter. They were going to have a meeting. They have had that meeting, as a matter of fact. If I just go ahead and tell us, so what is the latest development concerning this matter, which the NBA is concerned about?
Well, thank you very much. First, let me use this opportunity to state the position of the NBA with respect to what transpired, that the NBA condensed in very strong terms the siege on the Honorable Justice Mary Odili, GS's home, without any tangible reason having been given to today. So where we are now is that upon the siege on the Honorable Justice's home, the NBA didn't rush out to make a statement on that same day like some people were clamoring for, because we needed to know exactly what transpired. We needed to hear from the state operatives what transpired. As it happened, EFCC came out to deny knowing anything about it. The police came out. Even the office of the Attorney General came out to deny everything that had happened. So at the meeting at our emergency NEC meeting, a lot of suggestions was profiled by a lot of persons, but eventually what the resolution as it were was to set up a 3-man committee to engage to investigate and engage the authorities on what happened and to know exactly what had transpired. Because this is the first time in Nigeria I can record as this type of thing will happen, and the police are saying they don't know what happened. EFCC has said they were not involved. The Office of the Attorney General has said they don't know what happened. But we all know that this thing, the whole episode is based or grounded upon a court order, a warrant signed by a magistrate. So it is not far-fetched to know exactly how to proceed. So we have set up a 3-man committee, first, to go and investigate from the magistrate who were the persons who came before the magistrate to demand for that warrant, because they are not faceless, they are human beings. Then from there, we will proceed. Thank God the Inspector General of Police has said that they have arrested those who went for that, their personnel who went for that operation. However, we are not satisfied, because there is the names of those persons, the offices and the officers, and who gave that command have not been made known, and we demand that those informations be placed before the public immediately, because we cannot live in a situation of fear where persons were seen on TV, were seen on camera, besieging the house of the second highest ranking judicial officer in the country, and we still not to hear any name. All we are seeing is deniers.
So, the question
one of the questions, forward, like
one of the questions, my sincere apologies, one of the questions a number of people would be asking is, hey, it's sounding like this is some kind of rocket science, because, I mean, for so many people at various levels of authority in the country to say they're not aware of what has happened to such a high-ranking judicial officer begs a lot of questions. Add that to the allegations, or rather the position of the Supreme Court on this matter, and one wonders, with all the things that the body of SANs have said and allegations of attack on judiciary, efforts to undermine the judiciary, what do you think is playing out?
Well, personally, I've tried to rationalize it. This is the first time that even those involved, whether you like it or not, police officers went there, whether you like it or not, an order was given by court, and from the social media, the magistrate said that he was misled from, I say social media, so it's not 100% reliable, but the name of the Attorney General of the Federation was mentioned, or the office of the Attorney General was mentioned. And they are all denying. This is the first time I've not even heard a situation where there are even lies, or to say, well, it was a mistake or something. Total denial. So it's very difficult to fathom as to what exactly is happening. And that is the reason why the NBA is calling on the President of the Federal Republic of Nigeria, that the President of Nigeria cannot keep aloof on this issue. You can imagine a situation where the spokesman of the President come out to give clarifications on the arrest of Igboho and some other lesser issues. And this is a mighty issue for the third arm of government, for the basin of justice to be invaded, and we have not heard anything from the office of the President of the Federal Republic of Nigeria. Is totally, it's not tenable at all, and the NBA frowns at it. So we are calling on the President to please come and step into this matter, because some terrible things are about happening. We recall that this issue of homes of justices of the Supreme Court were invaded some years ago. Nothing happened. Nothing was said. But at least a reason was given. The Honorable Justice Onogen was removed unlawfully. Nothing, at least a reason was given. But this is the first time we are seeing this type of caliber of impunity. And there's no reason given at all. There's, everywhere is mute. We will not, I mean, it gives room to be fearful that Nigeria is no longer safe, that there are some dangerous persons who have taken a reign of powers, so much so that they can do and not do and just generally keep quiet without any person calling them to task. However, we voted for the President of the Federal Republic of Nigeria to steer the ship of the nation. So we are calling on him at this stage that we no longer feel safe. We are very sure that the judiciary is under threat, very serious threat, and we are very sure that when there is threat to the judiciary, then the country cannot be at peace. So we are calling on the President of the Federal Republic of Nigeria to please take up this matter, investigate this issue with presidential fiat as soon as possible. But now, I want to go back again to say the President of the Nigerian Bar has engaged the Chief Judge of the FCT, and we are informed that the magistrate has been queried. So we are patiently waiting for him to answer that query so that he can put answers to the questions that we are all waiting for, the questions nobody has answers to. Because persons came before him. He knew those who came before him. He knew those who swore to affidavit before him. So let him give us, put faces and names to the characters that came to apply for that warrant. However, we also want to make this point that the Inspector General of Police have said that they have arrested, they are investigating. The CJ also is investigating, but the NBA, we want to be observers in all this investigation. We don't want anything to be swept under the carpet. And let us make this point, that for once, this is an issue the NBA will not allow to be swept under the carpet. We are very ready to follow up, and the three-man committee we have set up is going to interact with the Attorney General of the Federation to have his perspective, because it's extremely very important when an allegation, whether reliable or not, have been made against that high office, for us to also have his view as to exactly what happened. Because orderly so, the NBA is investigating this matter. That's exactly what I'm trying to say. And we are not going to lie low until we find answers to the questions that are nagging.
When the Supreme Court released a statement that says the Supreme Court cannot only bark, it can also bite. Well, we don't understand what that means. But from a professional perspective, what do you think that implies, coming from the Supreme Court?
From my professional knowledge, the Supreme Court can only bite when a matter is placed before it. If there's no case before the Supreme Court, we hardly bite. But however, the NJC is the body that ought to bite. The NJC is under the control of the Chief Justice of Nigeria. So if the Supreme Court say we want to bite, we obviously are going to back through the NJC. Now the question is, we really have to go back again and look at all this is in proper perspective. When all these attacks were coming against the judiciary, what did the NJC do at this various time? The Supreme Court justices themselves, when the NBA declared a boycott of when Honorable Justice Walter Onogen was being persecuted, and the NBA, out of solidarity, declared a 3-day boycott. What happened? The courts were sitting. They didn't sit today. Now the ball is squarely in the court of the shame is now before all of us, and we now have to really address how we tackle issues like this. So we are saying that the NJC ought to make a statement, because NJC is actually the body that ought to take up this matter, not the Supreme Court in this sense. But the Supreme Court ought to make a statement to show their displeasure, which they have done. But to bite, really, except a matter is before the Supreme Court, how can the Supreme Court bite? But the NJC has the power to do so many other things. They have the power to investigate. Anyway, the magistrate is not under the NJC, but it's under the Judicial Service Commission of the FCT. The NJC can direct that the investigation be done. However, that investigation is ongoing. So we wait for the investigation to know exactly what the Judicial Service Commission, both at the national level and at the FCT level, will do to that magistrate. We also will be waiting.
Just a second, Mr.
With respect to the police,
when you say that the NJC hasn't been speaking, that sounds like a tiny bit of indictment against the NJC. If we haven't heard the NJC on this matter at all, what do you make of that? How significant is that for you?
I don't want to call it an indictment. I rather we call it a statement of fact, because to the best of my knowledge, they have not made a statement. Now, what do we make of it? The question is why? If that is the question, I really don't know why. And we are not too comfortable with the fact that is the NBA is not too comfortable with the fact that the NJC has not said anything as we speak. Even if they are not, at least we expect to hear a statement from them that we are going to investigate, we are going to find out, or we have found out this. No, everywhere is so silent. So you find out that this, it is a situation we have the state actors, the NJC not speaking, the Inspector General of Police have arrested, according to him, he has claimed that he has arrested those who were responsible. We don't have names, we don't have the ranks of those who went there, who gave the order, you know. So the Attorney General himself has said, I'm not aware of what happened. However, from the social media, like I said, the NBA, we don't want to rely on it, but you see, cannot run away from it. His name has been called. And all he has said, the deniers. I don't want to use the language of on the street. Are we not having unknown state actors in the situation in Nigeria where the bodies responsible for investigations are all denying what happened in the eyes of the world? So there's some sinister motive we cannot fathom. We don't know where it is coming from. But what we are saying from the NBA is that this will be the last of such. We will not allow it to go, because we are going to get to the very root of it. And if any lawyer is found wanting, that lawyer is sure to undergo disciplinary measures of the legal profession. And we also call on the NJC and also the Judicial Service Commission that if the magistrate is also found wanting, he must be disciplined. In fact, one of the reasons why we find that the judicial system, we are having issues like this, is because the disciplinary mechanism in the legal profession, i.e. the legal practitioner disciplinary committee and the NJC which disciplines judges, with due respect to all of them, have not been up and doing the way it ought to be up and doing. Because in about 20 years ago, we're not having these issues. So obviously they had very little petitions to treat. But now we have a deluge of petitions. It's like everything is turning upside down. And they have to now readdress and re-engineer the way they investigate this matter, so that persons who have the intention of derogating from their duties will know that punishment will come someday. Let me give you an example. The CCT chairman was alleged to have engaged in a public fight somewhere. Myself and the National Welfare Secretary of the Nigerian Bar Association, we wrote a petition to the Legal Practitioner Committee for him to be investigated and disciplined. As we speak, more than 7 months after, nothing has been done. So now the question you have to ask yourself, will such a man be afraid tomorrow to undertake any other extrajudicial activity? No. So the disparate mechanism of the legal profession, like I said, both for the judges and those for the lawyers, has to be engineered to fit for purpose of the present day Nigeria, because things are really going airy, and we really need to up our game.
I mean, that being the case, how then do you say that this is going to be the last? Because is there any guarantee that if the magistrate is found wanting, they will be made to face the music?
Yes. It is a matter of will. And let me make it very clear. This MBA under this administration, we have the will to pursue this matter to its logical conclusion. If any magistrate, if by the end of the investigation of the FCT Judicial Service Commission, that magistrate is found wanting, we will call for what should be discipline. Sanctions will be meted out on him. If any lawyer is found wanting, we are going to pursue it to ensure that such a lawyer is dealt with in accordance with law. And if the Attorney General, the Office of the Attorney General itself is found wanting, let me make the point that the NBA will not shy away from taking up that matter against the Attorney General in two places, i.e. the LPDC and the LPPC. That is the Legal Practitioners Disciplinary Committee and the Legal Practitioner Privileges Committee. So we are watching, and like I said, we have set up a 3-man committee which is investigating. It's upon their report we will know the next step to take, and be sure that this matter will not be swept under the carpet, because the encroachment, the threat to the rule of law in Nigeria, the threat to the independence of the judiciary has become very potent. It's not glaring. There's no hiding place, and the only place to hide is to fight these menace once and for all, and we are very ready for that.
In other words, you're saying point blank, even if it is the AGF that is responsible, the actions will be taken.
Be very sure of that. If the AGF is found wanting, actions will be taken against him. We will pursue it.
So How does this address the wider challenge? Because, I mean, we've talked about in a different session how the appointment of judges is crucial to ensuring that some of these things don't happen. What kind of effort do you think is being made to address that?
Well, I thank you for bringing me back to that. My initial comment on this issue was that, indeed, if the appointment of judicial officers is not reviewed, the mode of appointment is not reviewed, these matters will keep coming up and on and on. Because, first of all, to be a judge, to be a judicial officer, you must have integrity, you must have knowledge, and you must have the courage to stand. Now, let's put this issue that is before us. A magistrate has signed warrants, and if you look at his statement, in less than 24 hours, he has granted he signed the warrant. In less than 24 hours, he has revoked them. Who appeared before him? Who at what point did the court sit? You know, it gives room to question the knowledge of I'm not questioning because we don't have the full facts, but it gives you room to wonder at what point will such a person be made a judicial officer. The appointment, if an appointment is made, and these persons who are appointed owe their allegiance not to the Constitution of the Federal Republic of Nigeria, but to some other interests, this is what you always get. Secondly, when somebody is not so sure, when you don't have knowledge, you are very, very scared, and at most time you make mistakes. So it is extremely necessary to make sure that the best are elevated to the bench. What do you see when I entered this profession in about 30 years ago? The persons that are elevated to the bench are usually lawyers who have practiced hard. They know the nuances. They know all that it takes to practice. Before you put the application before you, they know your intention. They know what you're after. But now, what do you have in the judicial service now? Most judges are coming from the registry. They never practice law. They were not pushing papers with due respect. So there is a limitation. Then secondly, you find some persons who have not practiced law, who have been in private business totally unrelated to law, and now sitting on the bench. There is no way, even for us who have, even the senior advocates of Nigeria, lawyers above 30 years, they still have time to ponder on issues of law, sometimes because you don't know it all. But from the experience, it guides you. But in the situation where persons who have never practiced before, who have never practiced law before, and what you hear is that they will learn on the job. But in learning on the job, they are putting the destinies of families, they are putting the destinies of generations into jeopardy. So Nigerians must make sure that the mode of appointment of judges be reviewed to ensure that the best will naturally get to on the bench to adjudicate. But in the situation where it is the daughters, children of the rich, the powerful are on the bench, what you expect is that they will protect the interests of their parents. They will protect the interests of the persons who put them there at any time. So they don't have empathy for the rule of law. They don't have empathy for justice. All they are just interested in is, how will this serve the interests of those who put us or appointed us to the bench? I'm very sorry to say what I'm saying, but that is the truth. And until we tell ourselves the truth, all this we are saying will be a recurring decimal in the history of Nigeria. And if Nigeria is not careful, where there's no justice, we have chaos. And where there's chaos, there won't be Nigeria.
Is that what you think is happening, what you just said now?
Let me say it again. I'm having the opportunity to say this. I was a chairman of a branch. I know how judges were appointed. Now I'm the first vice president of Nigeria. I know how judges are appointed. Recently, judges were appointed in my state. I don't want to call name. Was appointed in my state. My branch had reason to complain to the NJC that we have issues with this. They never responded to that letter. We wrote another petition. They didn't respond until they went ahead and made the appointments that we had issues with. They never even gave us even the opportunity to ventilate the reasons why we believe that this person was not fit and proper to be a judge. So in the situation where the bar cannot be heard in the appointment of judges, I wonder which other body can be heard. So when they are doing things the way they like doing things, and we're not reaping the results, well, we are reaping the results. So I just don't know. We just have to say it the way it is.
Are you questioning the independence of the judiciary?
No, I'm questioning the appointment of judicial officers. Not
by that I mean, are you saying that the judiciary is not independent enough?
Yes, the judiciary is not independent enough because the executive, let me put it clearly, the executive have a say in how judges are appointed. And in that say, that is where they manipulate the independence of the judiciary. Get that very clear. The second aspect is the funding of the judiciary. Again and again, this issue of autonomy has been on. And if you don't really understand what it means for the fund, if you don't really understand what it means for a judiciary to be autonomous, then we will not get anywhere. Most persons believe, and I keep saying it over and over again, and I want to say this in again, that the benevolence of the executive does not translate to the funding of or the autonomy of the judiciary. What belongs to you, somebody keeps it and now gives you, that does not mean that that puts you under his control. But what is meant for the judiciary, if it's given to the judiciary, then the judiciary will now the independence will be assured. Then secondly, I want to make this point. Thank God I'm here to this morning. I want to make this point. Even the federal judiciary, that is, it is not, I will repeat with due respect, it is not autonomous. Why? Because they have what they call the budget envelope. That budget envelope is the control of the judiciary by the executive. How? Rather than the constitution made provision for the judiciary, the legislature, and the executive to sit on the round table and determine the budget. But what we have in Nigeria is the executive we give a ceiling that the budget for the judiciary will not be more than 90 billion or 90 million for this year. So they have allocated to you. Despite your need is not necessary. This is what the executive is allocating. They now give it to you. You spend it, you think you are autonomous. You are really not autonomous because the constitution says you are to sit as an equal on the table to discuss budgeting. But however, the executive don't allow you to sit on the same table to discuss budgeting. They rather allocate to you what will be given to you, then they not give you the money. But at the state level, they don't even they allocate to this the judiciary, but they don't even give the money to the judiciary. They say hold it and release as the judiciary make a requisition for same. So you find a situation where the constitution actually guaranteed the independence of the judiciary, but the operators of the constitution have refused to make the judiciary independent. And the judiciary find it very difficult to speak because by tradition, the bench does not speak. It's the bar that speaks. So the body forced on the NBA to speak out. So when I'm speaking out, I'm not speaking out just because I want to speak, because I was elected to speak on behalf of the judiciary by the members of the bar. So I'm only doing my duties, and we must continue to speak out so that Nigeria, these issues we are raising can be reviewed and Nigeria will move forward. Now the constitution is before the constitution, 1999 constitution is again at the review stage at the National Assembly. We call on the National Assembly to again look at the mode of appointment of judges, look at the mode of funding of the judiciary. If this is not holistically done, with the intention to remove it from the control of the executive, we will cry and cry over the years until we really get worse.
Do you think it's time for the bar to speak?
The bar is speaking, but well,
the bar is speaking, the bench, sorry, I meant the bench. In some countries, the bench they do speak.
Well, it depends on there are different types of jurisdiction. The jurisdiction that operates in Nigeria, the English system, the bench don't speak. The bar speaks on behalf of the bench.
What do you think can go wrong if they speak?
I will give you a classic example. I can't remember the name of the judge. I think it was known in those states. A judge wrote, I think it's a memo or something like that, to the governor and complained of some things. What happened? She was removed from office. So it's just a tradition. And by law, the bench can't speak because they're arbiters. By the time they start speaking on such issues, they have descended into the arena. A judge that that speaks or it is making adverse comment against the executive, how do you think the executive will be comfortable when matter comes before that same judge for adjudication? So they can't speak. But I don't think they lose anything by not speaking, because we speak on their behalf. The NBA has not shied away from speaking on their behalf. At every given time we speak. But the problem again is that the bench themselves, they are not close to the bar the way it ought to be, the way it was before. They sometimes don't even tell us what their problems are. Sometimes when we even want to fight some of the ills that militates against their independence, you find out that with due respect to them, they seem not to understand. Sometimes they even undermine the fight of the bar on their behalf. So, like I say again, it boils down to the appointment of judges. Yeah, but I are appointed to the bench.
One wonders if it's the same thing.
The need of the synergy between the bar and the bench.
Is it the same thing if a judge speaks or if they have spokesperson for judges who then issue statements on their behalf?
See, the NJC looks after the general affair of the bench at the national level, while the JSC, they look after, they have the right to speak on such issues that have to do with welfare or that has to do with the constitutional terms of preference of those bodies. But some of these things go beyond all those bodies. And the bench can actually speak during valedictory court sessions. They have a right to speak. During judgments, sometimes some judges use the opportunity of a case they are delivering judgment on to speak on some salient issues in the society. They can actually speak, but they cannot agitate. Let me put it, maybe that's the difference. Not that they cannot really speak at all. They do speak through the, maybe during valedictory court section, they do speak through their judgment, but they can't agitate. Judges cannot be agitators, for God's sake. They are judges. That's the highest level of. Judges like mini gods. So don't expect them to be agitated.
Just a second. You know, it's interesting when you say that we're practicing the judicial. Our judicial system is patterned after the UK, while we are practicing a presidential system of government from the US. It's very interesting. So, in terms of the appointment of judges, I'm just wondering, what are the options before us if we are to ensure the independence of the judiciary? Because the president cannot willy-nilly, or the state governor cannot willy-nilly remove the president of the Senate or the Speaker of the House of Assembly or the Speaker of the House of Representatives at that. But just as you said, the president or anyone in the executive at that can initiate a process that can remove the judge or the justice or any judicial officer. What kind of modifications would you be proposing?
First, on the appointments, the Constitution provides that a judge should be, I think, 10 years post-call for you to qualify to be a judge. Nothing else. That is not sufficient. There are so many lawyers who, upon graduation, never practiced law, never had anything to do with law, but upon attainment of 10 years post-call, they are constitutionally qualified to be judges. And that is where our people will not rather look beyond the bare requirement. They just say, okay, simply because the person is an above 10 years, because the person was selling, was doing other things, but is qualified and he has the opportunity because he has the political connection, they not appoint such a person to be a judge. Whereas, indeed, for you, that 10 years post-call is not enough. For you to sit as an arbiter, you must first of all be able to appreciate the issues that were brought before you, both by way of facts and by way of law, and by way of what you expect the society to be going before you can give a judgment. So, first and foremost, I personally, I advocate that it is not sufficient to say that once you are 10 years post-call, you are qualified to be a judge. There should be other requirement to say you have done cases to just like requirements to be a SCN, you have done cases like in the High Court, you have done cases in the Court of Appeal, how many cases you have done within a period of years, then that will be sufficient to say you now have some sufficient understanding of what the practice of law is. Secondly, I also do think that the appointment should not be, how do we appoint judges now? The JSC or the JSC of the state, that the Judicial Service Commission of the state, just make an advert. That is what the law says. They were not doing it, but some of the states are now copying it. They call for those who want to be judges, and they just on their own, without any further ado, select those they believe have made they want, and send their name to the NJC, who will look at the list, and because they rely on the JSC, will naturally go through. Now the question is the NJC that now filters, that ought to filter the appointees. Who are they? The chairman of that body is the chief judge of the state. The attorney general is there, and two other members, yes. And I think there are usually about 5 to 7 members. They are all appointed by who? They are all appointed by the governor of the state. So immediately the governor has appointed the JSC. What do you expect? The appointees are there. They are the persons who eventually will determine who and who will be appointed as judges. That is where the problem is. So I am calling for the fact that an independent body be set up for the appointment of judges that will not have that body will not be appointed by the chief executive of a state, but rather probably from members of the from the bar. We know ourselves. So if the bar is made to play a very, very important role in the appointment of judges, I think the system will be better than what we are having now.
Because we also know that in some claims they elect judges. So who knows how that will play out here. So you think it will be a good idea here as well?
Well, I will not call for election of judges. That is, everybody should elect. But if there must be an election, that election should be done by the bar. The lawyers themselves will know ourselves. The election should be done by the bar. So if the bar is made to play a more prominent role in the appointment of judges, Nigeria will be better for it.
All right, then. Thank you very much indeed, Mr. John Aipokwo-Martins, first Vice President of the NBA.
Thank you very much.